Hello and welcome to Narayana IAS. Dear viewers, Narayana IAS bring before you a special video. Now in this series we are going to pick one important article from the Hindu or Indian Express which is important for the UPSC examination. Now discussing this article is going to be extremely crucial for the students to understand nuances about the article, different dimensions of the article which can be important or which for sure will be important for the UPSC examination. So viewers, today we have chose a topic from the Indian Express. The title of the topic is Supreme Court to revisit. So here we see the Supreme Court to revisit the 1995 order on suing doctors in consumer court, which means the Supreme Court had given a judgment in the year 1995. Now the Supreme Court wants to revise its decision or judgment which it had given in the year 1995. Right? So let's try to understand this topic holistically. Now, when it comes to this topic, there are few key terms that you need to understand as a part of the UPSC examination. For example, we have the Consumer Protection Act of 1986. At the same time, we have the Consumer Protection Authority, which enforces the rights of the consumers. And again, you can map this particular topic under GS paper 2. In GS paper 2, we have a subtopic in the name important aspects of transparency, governance and accountability. So why is this topic important? Because a question in the UPSC can be asked of this nature. So here the question talks about the consumer rights and privileges under the law of our country. So here we get to see few statements, and based on your understanding of the consumer rights and privileges, you can be in a position to attempt this particular question. Right. So let's get started. To start with the context. Now what is the context? The context, as I mentioned earlier, is that the Supreme Court on May 14, 2024 is considering to revisit its judgment given in the year 1995. Now the two-judge bench of the Supreme Court on May 14, 2024 requested the Chief Justice of India to constitute a larger bench. Why? To revisit the 1995 judgment, which means the Supreme Court wants to change the judgment that it had given in the year 1995. Let's try to know more about the topic. What was the 1995 judgment? The name of the 1995 judgment was VP Shanta case. Now, viewers, in the VP Shanta case, the Supreme Court ruled that the medical professionals, like the doctors, provide a service as defined in the Consumer Protection Act. So, as per the 1995 judgment, right, the medical professionals like doctor, they provide a service as defined in the Consumer Protection Act, which essentially means that the consumers have the right to file lawsuits in the consumer court against the medical professionals, which means the medical professionals like doctors was brought under the purview of the Consumer Protection Act. This is the 1995 judgment. The ruling classified medical services under the purview of CPA, which means essentially if any consumer is not satisfied with the services provided by the doctor, he or she can approach the consumer court. But now the current debate, it questions whether the CPA should apply to professional services provided by the doctors. As of now, yes, it applies. The question is, why did this question or debate arose? Because of the judgment given on May 14, 2024. And what was the judgment? So on May 14, 2024, the two-judge bench of the Supreme Court held that professionals such as lawyers cannot be sued under the Consumer Protection Authority. So the question is, when the lawyers cannot be sued under the Consumer Protection Authority, how can the doctors be sued? That's the reason the two-judge bench of the Supreme Court has requested the Chief Justice of India to constitute a larger bench so that the 1995 judgment can be revised or can be changed. So, the May 14 judgment distinguished between professionals and those engaged in business or trade, which means the Supreme Court held that the services provided by the professionals cannot be put at the same level as that of the services provided by the businessmen or traders, which means the services provided by the businessmen or traders is different than the services provided by the professionals such as lawyers and doctors. I hope viewers, students, you understood the context. Am I right? Now, it is very important for you all to understand the Consumer Protection Act 1986 because a question can be asked in the prelims regarding the provisions of the CPA 1986. So, what exactly is this act or legislation? Now, this act was enacted. Why? In order to safeguard the rights of the consumers. To safeguard the rights of the consumers against what? Against the unfair trade practices and exploitation. Let's try to understand this point with the help of an example. There are many products in the market which claim that their products have the capacity to cure many diseases. Now, this is what the company claims, right? But in reality, the product does not cure any disease. Now, here the companies are using unfair trade practices to attract more and more consumers to buy the product. Here the consumers have used unfair practice in order to attract the consumer. This is wrong. So, the Consumer Protection Act, it protects the rights of the consumers against exploitation and unfair trade practices. And if a citizen or a consumer has to raise a grievance or raise a complaint, there are three platforms. These three platforms are quasi-judicial machinery established at three levels. One is at the district, the second one is at the state, the third one is at the national level. So, at the district level, we have the District Consumer Disputes Redressal Commission. At the state level, we have the State Consumer Disputes Redressal Commission. And at the national level, we have the National Consumer Disputes Redressal Commission. And these commissions, they adjudicate cases filed by the consumers. I hope you understood the main provisions of this particular act. Few more provisions. Now, in 2019, the central government had amended the 1986 Act. Now, this amended act, it repealed the Parent Act of 1986. Why? So as to address the contemporary challenges faced by the consumers. For example, under the amended Act of 2019, the central government had established Center Consumer Protection Authority. The mandate of this authority is to promote, protect and enforce the rights of the consumers. Now, this authority has the right to investigate and also take action against unfair trade practices. Then, the amended Act of 2019, students, has expanded the definition of consumer. Now, here consumer also means the people who engage in online transactions, which also includes e-commerce platform as well. At the same time, this act, the Act of 19, it enhanced the penalties for misleading advertisements and unfair trade practices. Now, students, you must have come across a news wherein few coaching institutes were claiming that XYZ number of students had taken coaching from their institute and cleared the examination. Though their claims were false, now here this act has a provision wherein they can enhance the penalty for misleading the people through the advertisement. So, these are the provisions of the Consumer Protection Act 1986, right? Now, the Consumer Protection Act, right, it excludes services provided free of charge. So, it excludes services provided free of charge and those under contract of personal service. So, we will try to understand this term. Now, the Supreme Court has identified three types of services in medical profession. One, which is free for everyone. The second, which is paid. And third, which is free for certain categories of people who are not in a position to pay. Here, in this provision, the court noted that the CPA, that is the Consumer Protection Act, was intended to protect all the consumers. But here, the services which are free is not brought under the mandate of CPA, which essentially means that the people who can afford to pay, they can file a complaint, but people who cannot afford to pay and are getting services free, they cannot file a complaint before the consumer court. Here the court noted that by having this provision, it is leading to, or it is resulting in, inequities, which means the ones who have the ability or who can afford to pay money for the services, they can file a complaint, and those who cannot afford to pay the money, they do not have any right to file a complaint. And that's the reason, to avoid this, the court held that the third services, the third, that is free for certain categories of people, should also be brought under CPA, that is Consumer Protection Act. Now, let's try to understand this term contract of personal service. The court held that the medical professional does not constitute a contract of personal service. Why? Because this contract of personal service is only confined or limited to an employer and employee relationship. Now, since there is no master-servant relationship between the doctor and the patient, so the contract between a medical practitioner and patient cannot be treated as a part of contract of personal service. This is what the court observed or noted. Now, in conclusion, we can say that the Supreme Court's decision to revisit the 1995 judgment, it reflects ongoing debates about the responsibilities and liabilities of the medical professionals. Now, the judgment will determine to what extent the medical professionals like doctors will be held accountable. The article doesn't mean to state that the medical professionals should not be held accountable. They should be held accountable, but to what extent they should be held accountable is something that the Supreme Court has to decide. So viewers, I hope you understood this particular article. Now, once you understand this article, it will be interesting for you to understand the Supreme Court proceedings and final judgment of the Supreme Court. I hope you enjoyed the session. If you want us to continue with such special videos, please do like, share and subscribe Narayana IAS. Thank you so much.